I'm Ash Khurana. I'm a consultant spinal surgeon at NR Bevan University Health Board in South Wales. This is the last hour before lunch, but we have a ever interesting topic and an equally fascinating panel. To start with, joining us virtually is Dr. Alex Crowe. He's a consultant nephrologist with his background. He joined NHS Resolution in November 2021 and is now the Deputy Director for Safety and Learning with NHS Resolution. Prior to this, he was Executive Medical Director and Chief Clinical Information Officer at Warrington and Halton Foundation NHS Trust. So over to Alex Crowe, please. Virtually.
Hello, and many thanks to BritSpine, the British Association of Spinal Surgeons, and also Rajan Verma for inviting me to support this particular session on consent in the Montgomery era for spinal surgeons. My name's Alex Crowe, and I'm Deputy Director for Safety and Learning at NHS Resolution, and I'm also a clinician and nephrologist, a practicing nephrologist. I'm going to start by talking to you about NHS Resolution and what this is about. This organisation is an arm's length body and supports the indemnity for England. You can see there our department, Safety and Learning, but the vast majority of the work that NHS Resolution does is within the claims department, supporting the indemnity schemes such as the clinical negligence scheme for trusts, the liability and third-party scheme, and the clinical negligence scheme for GPs. You will also notice within NHS Resolution the practitioner performance advice, and many of you will recognise this, supporting managing and resolving concerns in relation to individual practitioners. This slide gives you some understanding of the value and volume of our claims over a year. This is 21-22. You can see that the value in this slide is over £6 billion, and I can say that last year that the cost of claims was £13.3 billion. The volume, so 10,000 to 11,000 claims per year, appears to be fairly static, but we still need to understand what the particular impact of the COVID-19 pandemic has had on claims and the processing of claims. You can see within this split donut that obstetrics occupies 62% of costs, but only 12% of volume. And you can see that the predominant contributors to claims lie within the surgical specialties as well as emergency medicine. And you can see neurosurgery there at 2%. Within the Safety and Learning department, we utilise a scorecard, which is a quality improvement tool which has 10 years of claims data. And we compartmentalise claims into being of high value, i.e. more than £1 million in costs, or high volume, where there have been more than 3 claims for a particular specialty. And our Safety and Learning team are available to provide a learning from claims offer to organisations to help them understand their claims data. The scorecards can identify themes within clinical services, and subsequently it may be useful to align a claim with or themes to a number of recommendations which may require prioritisation. And then understanding that if a claim is to be reduced in terms of frequency, then that recommendation would need to be implemented. So we provide a brand to support this particular template. It's quite key to understand why people claim, and this was a very useful bit of work from the Behavioural Insights team, who looked at 728 patient claimants. And there were some interesting banner headlines from this, where only less than a third of those claimants received an apology. And we very much support through a number of educational materials that saying sorry is not admission of liability, but it is the start of understanding where there was less than perfect care. As well as understanding the patient's set of circumstances, it's also important to understand if measures have been taken such that the events would not happen again. And in this particular report, only 6% of the claimants felt that the actions taken would prevent recurrence. And therefore, the argument over understanding how recommendations should be implemented to reduce future claims. So not only reducing the cost in financial terms, but also in terms of the human cost to the patients, their families, and also the clinicians involved in the care of the patient. So I think this caricature cartoon pretty much sums up how informed consent can be looked at, and it is at times quite complex, understanding that there is a healthcare professional, a patient, and many options to consider. Consent is key to ensure that we protect the rights of the individual and that we protect the individual from undesirable outcomes. It's important to prompt us to think about what the risk benefits are as far as doing nothing is concerned, understand the alternative treatments that are available and the risk benefits are associated. And within all of this, the material risks that go with the patient. So understanding the patient's set of circumstances, their motivation and their risk appetite. And I'd like to direct you to a good piece of work that GIRFT have completed on the high volume, low cost consent forms, which itemize risk in terms of expected, common, i.e. 1 in 20, uncommon, more than 1 in 20 procedures is where it occurs in more than 1 in 100. There are 59 of these procedures, for example, in orthopedics, the partial knee replacement. Very useful. This is a representation of some information that we put together from April 2012 to March 2017, and it looks at claims associated with failure of informed consent, and you can see where predominantly the consent claims have come from in terms of orthopedic surgery, gynecology, general surgery, obstetrics and urology. And of those 1,223, £233 million so far. We have seen the claims associated with consent increase, and but we are on a plateau at the moment. We're unsure as to whether this is having an impact has occurred as a result of the COVID-19 pandemic. So we can look at claims in terms of region, and you can see there the region and the number of claims in terms of the number and the percentage. So the North East and Yorkshire at the top there. But I think it's important to understand that there could be very easy explanations for this in terms of the number of procedures, but also understanding the population demographics and the complexity that might be associated with those procedures. We also could look at the claims in terms of the top 10 specialties, and again it sort of iterates what you've seen earlier, that gynecology, orthopedic surgery, general surgery, obstetrics and urology are the top contributors to claims associated with consent. We are in the process of developing a Power BI dashboard for your data, and this is quite exciting because I think that it will give you an up-to-date dynamic understanding of what the claims data looks like rather than an annual update. So it will be a continuum, and it will give you all sorts of information about, for example, the average number of years from incident to notification of a claim, which is currently for consent 4.3 years, and the time period between the notification to close a claim, which is currently at 2 years. There is also the opportunity to look at specialty, the type of injury and cause, and currently associated with consent. The top 3 are unnecessary pain, nerve injury, bowel damage, or bowel dysfunction. So just closing off the last few slides here, we've got some example of consent claims, and here is the first one. Presenting information in a balanced way is always important. Sometimes as clinicians we try and reassure patients that there is a positive outcome, but it is really important to understand the risks that go with the procedure and understanding the alternatives that are available. It's also important to give the patient time to reflect, and I think that evidence of documentation in terms of letters, patient information sheets, consent forms can all be very useful. There's a risk that the aim of treatment may not be achieved, in fact exacerbating things and making things worse in the second example. And so again, the importance of risk. And then lastly, understanding the consequences of doing nothing, but also the procedure itself, the risk benefits, and also any alternatives that may be available. Again, really key to provide that holistic picture to the patient with good documentation, and to avoid having to verbally back up what may have happened by saying my invariable practice is. So we do have a range of products for learning, which include the benefits of supported decision making, which are within the Did You Know leaflets. We've also got some animations in relation to duty of candor, and a really good spinal podcast. I would also direct you to our consent page, where Nadine Montgomery's story is told in terms of videos from Nadine herself and her experiences, and understanding from an advisory perspective a lawyer's approach and how we can learn and ensure measures are taken that things like that do not happen again. So thank you very much indeed for listening, and I hope to be able to join you later on for questions and any comments that you may had. I would encourage you to contact us if you would like to take up the Learning from Claims offer, and we can arrange to meet you. Thank you very much.
Thank you, Alex. I think we'll keep the questions to the end for all the 3 speakers. So we'll move on to the next speaker, and I'm pleased to invite Christopher Melton, KC. He's a standout silk who excels in representing claimants in high-value catastrophic injury and clinical negligence claims, including spinal injury. He regularly pleads in Supreme Court and Court of Appeal He took Silk in 2001 and then became a senior counsel to the Shipman Inquiry for 4 years. Since then, he has acted exclusively for claimants and bereaved families. So today we'll hear the perspective of Christopher Melton on consenting.
Thank you.
Thank you.
I'll assume you can hear me at the back unless you shout out. 2 things to begin with. Thanks, Alex. Alex began by mentioning the cost in billions of pounds of these cases. But then, as I expected, he also alluded to, which we see all the time, the human cost. And when he mentioned the human cost, he identified not only the effect on the families, but also the practitioners involved. And I'd have to say that it's my personal professional experience at the higher level of cases, and this wasn't always the case, that NHSR does demonstrate a genuine interest in not only the injured people, but also in the practitioners who are involved. And the fact that NHSR has set up his group, which intends to learn through mistakes, is a way forward. But the figures involved and the human catastrophes involved, particularly in the obstetric cases, which themselves often involve consent, is a demonstration that we've still got quite a long way to go. The other thing is that, as you'll have heard, and the last time I spoke north of the border was when my son was at St Andrews, I was counsel to the Shipman Inquiry. I was engaged by the Department of Health and by the Home Office jointly. And one of the things that we lamented was the passing, effectively, of a good complaint system and of a good patient advisory system, which seemed to us to be, when that proper system existed, patients thought that they had a proper voice. But once the system disappeared, more and more people went into litigation. Those are 2 asides. I'm going to talk to you for about 10 or 15 minutes about the history of consent and where we're up to now with Montgomery. I want to start in the 1950s with the Bolam case. You'll know the Bolam test. Mr. Bolam was a voluntary patient at the Friern Hospital, a mental health institution. He agreed to undergo ECT. He wasn't given anything to relax his muscles, any muscle relaxant, and his body wasn't restrained during the procedure. And during the course of the procedure, he flailed about violently. The procedure was stopped, but by that time he'd already suffered a broken acetabulum, such was the flailing, and he sued the hospital. He said that they were negligent for not issuing restraints, that they were negligent for not issuing relaxants, and that they were negligent for not warning him about the risks involved in ECT. At trial, the experts, effectively both sides, said, well, actually, there's 2 schools of thought about each of those things, and you could not find a prevailing common practice among the profession one way or the other. The upshot was that the claimant lost. The claimant lost both in relation to the failure to provide the relaxants and also in connection with the failure to provide proper consent. What the judge said in a more paternalistic time, we would say in the 1950s, was this: the true test of establishing negligence in diagnosis or treatment on the part of a doctor was whether the doctor has acted in accordance with a practice accepted as proper by a responsible body of medical men, or women of course, skilled in that particular art. That passage has been quoted very frequently and still serves as the basic rule for professional negligence. The then prevailing practice was not to give a warning, and so the claimant failed. So long as the doctor can show that the doctor acted in accordance with the responsible body of what's going on at the time, there is and can be no liability. That practice was revised slightly, or rather that state of affairs was modified slightly with the case of Belitho. This is the Belitho gloss on bolum, which says that if the practice can't withstand logic, then the claimant wins anyway. But in Sidaway, in the 1980s, the position barely changed. This was, in fact, a neurosurgery or spinal surgery case. The claimant suffered from pain in her neck, her right shoulder, and her arms. Her neurosurgeon took her consent for cervical cord decompression, but didn't include in his explanation the fact that in less than 1% of cases, decompression can lead to paraplegia. She developed paraplegia after the operation. Rejecting her claim for damages, the court held that consent did not require an elaborate explanation of remote side effects. So even in 1980, after I came to the bar, as it so happens, the so-called paternalistic approach prevailed. Lord Diplo said, so the Supreme Court comprises the very best judges, the very best lawyers of the contemporary times. There are normally 5, sometimes in big cases 7 of them. If you don't agree with what the others say, that's called a dissenting opinion. The majority opinion was that it was delivered by Lord Diplo. He said this: we are concerned here with the claimant arguing that the doctor should volunteer unsought information about risks of the proposed treatment, failing to achieve the results sought, or making the patient's physical or mental condition worse rather than better. The only effect that mention of risk can have on the patient's mind, if it has any effect at all, can be in the direction of deterring the patient from undergoing the treatment which, in the expert opinion of the doctor, it is in the patient's interest to undergo. So the doctor is the judge of what's in the patient's best interests. To continue the quote, to decide what risks, the existence of which a patient should be voluntarily warned, and the terms in which such warning, if any, should be given, having regard to the effect that the brackets chilling, close brackets, effect that that warning may have, is as much an exercise of professional skill and judgment as any other part of the doctor's comprehensive duty of care to the individual patient. And expert medical evidence on this matter should be treated in just the same way. The Boland test should be applied. In other words, the doctor, the medical profession decides what information has to be given, and the motivating force is what the doctor thinks is in the patient's best interest. That was in 1985. But there was a dissenting voice in Lord Scarman, the author, as some of you will remember, of the report on the Brixton riots, and probably one of the greatest lawyers of that generation. I won't describe it as mine because I'm still going, and he sadly isn't. In dissent, Lord Scarman said that the Boland test should not apply to the issue of informed consent, and that a doctor should have a duty to tell the patient of the inherent and material risk of the treatment proposed. Lord Scarman said this: the decision whether to consent the treatment proposed did not depend solely on medical considerations. A patient may well have in mind certain circumstances, objectives and values which he may reasonably not make known to the doctor, but which may lead him to a different decision from that suggested by purely medical opinion. But even though the position was clear, 4-1 in favour of the defender in Sidaway, the profession remained troubled, or rather the legal profession remained troubled, and probably the medical profession too, about this idea of the medical profession abrogating to itself the decision as what's in the claimant's best interests. And as it so happens, it came up, and Lauren was the counsel who took up cudgels effectively north of the border in the case of Montgomery against Lanarkshire. As you know, probably the claimant was a pregnant woman of small stature and suffering from diabetes under the care of a doctor during her pregnancy and eventual labour. The doctor didn't tell her of the 9 to 10% risk of shoulder dystocia, as the doctor viewed the problem of shoulder dystocia as being statistically relatively small, and in terms of possible bad outcomes, very slight. And she didn't see, and these were, I think, her words, the caesarean section as being in the claimant's best interests. The Court of Session in Scotland ruled that there was no negligence because the doctor was acting in accordance with prevalent practice and, in brackets, in the patient's best interests. But when the case went down south to the Supreme Court, and for the first time, a requirement was affirmed by the Supreme Court of informed choice or informed consent by patients in medical treatment that rests fundamentally on the duty of disclosure by medical practitioners. So how or why had things changed? First of all, the why. The lead judgments, as I said before, there are normally 5. On this occasion there were 7. They were given by 2 of the most eminent, no disrespect to the others, of their generation, Lord Reid and Lord Kerr, who sadly recently died. Why? 1, patients are now, quote, widely regarded as persons holding rights rather than as the passive recipients of the care of the medical profession. They are also widely treated as consumers exercising choices. 2, it is now untenable to assume that patients will be medically uninformed and incapable of understanding medical matters. 3, the right of autonomy is now more clearly established than before, and respect for the dignity of patients requires no less than that they should have autonomy in their decision makers. In other words, they're the actors in the decision, albeit that the doctor is going to be actor in the consequences of that decision if the decision is in favour of surgery, which it may not be. 4, these factors, the first 3, point away from a model of the relationship between the doctor and the patient based on medical paternalism. They also point away from a model based on a view of the patient as being entirely dependent on information provided by the doctor. What they point towards is an approach to the law which, instead of treating patients as placing themselves in the hands of their doctors, treats them so far as possible as adults who are capable of understanding that medical treatment is uncertain of success and may involve risks, accepting themselves, the patients, responsibility for the taking of risks affecting their own lives and living with the consequences of their choices. 5, the duty of care on the part of the doctor is the counterpoint of the patient's entitlement whether to decide whether or not to incur that risk. And the patient's entitlement and the patient's assessment of that risk doesn't depend exclusively on medical considerations. What Lord Kerr, what Lord Kerr and Lord Reid said is set out, and you can get this on the Supreme Court website, and I'd urge you to read it. It's at paragraphs 84 to 87, and it is only in those paragraphs that they summarise and explain in greater detail than I have time to today the reasoning. In effect, the Bolam test applies, yes, to your understanding as doctors of the risks, the surgical, in your cases, risks involved. But the Bolam test doesn't apply to the judgment that has to be made ultimately by the patient and as to the information that the patient should be given about the patient's acceptance or otherwise of those risks. So what guidance, if any, was given going forward? Lord Kerr and Lord Reid said as follows. First, it follows from this approach that the assessment of whether a risk is material cannot be reduced to percentages. The significance of a given risk is likely to reflect a variety of factors beside its magnitude. Speaking slowly because they have 6 or 8 weeks to write these judgments, and the language that they use captures perfectly the essence, really, of what we're talking about when we're talking about consent. The significance of a given risk is likely to reflect a variety of factors beside its magnitude. For example, the nature of the risk, the effect which its occurrence would have upon the lifetime of this patient, the importance to this patient of the benefits sought to be achieved by the treatment, the alternatives available, and the risks also involved in those alternatives. The assessment is therefore fact-sensitive, and sensitive particularly to the characteristics of the patient. That's the first guidance going forward. The second bit of guidance going forward, there are 3, and I'm going to finish in a minute and a half. Secondly, the doctor's advisory role involves dialogue, the aim of which is to ensure that the patient understands the seriousness of her condition and the anticipated benefits and risks of the proposed treatment and any reasonable alternatives. Lauren's going to deal with the doctor's duty in connection with reasonable alternatives shortly, because by coincidence, in 2.5 weeks' time, she's back in the Supreme Court on the reasonable alternatives point in the case of McCullough. The role will only be performed effectively if the information provided is comprehensible. The doctor's duty is not therefore fulfilled by bombarding the patient with technical information which she cannot reasonably be expected to grasp, let alone by routinely demanding her signature on a consent form. Third, it's important that the therapeutic exception, I know what's in the patient's best interest and I will prevail, should not be abused. It's a very limited exception to the general principle that the patient should make the decision whether to undergo a proposed course of treatment. It's not intended to subvert that principle by enabling the doctor to prevent the patient from making an informed choice, where she is liable to make a choice which the doctor considers to be contrary to her best interests. Lauren will now deal with the scope of the duty in relation to alternative treatments. There'll be 10 minutes afterwards for questions, and one of the questions may be whether it's wise or sensible to have your consultation processes video or sound recorded or similar.
Thank you very much, Christopher. May I invite Lauren Sutherland, KC. Lauren took Silk in 2016. She specializes in personal injury and medical negligence work. Lauren was a counsel in the landmark Montgomery case and has published a book on consent post-Montgomery as well. She has been heavily involved in teaching lawyers, doctors, and medical experts with emphasis on consent and medical ethics.
Thank you, and thank you to BritSpine for asking me to speak today at this wonderful event and in Glasgow, which is always great to come and visit Glasgow, having lived here for a bit but moved to Edinburgh and now working in Manchester. So, was Montgomery a step too far? Many think it was a step too far, and I understand that, but it really was something that was it grew out of teaching doctors and dentists for 20 years before Montgomery actually happened. And really it goes back to basic ethics. And what I did was say to the students, there is the legal stick, which will hit you if you do something wrong, but there's ethical practice. And what you want to be as a professional is ethical practitioners, hopefully. And so the whole point of Montgomery for me to pull it down is patient autonomy, patient choice. And it does recognise, it goes to the core of it, that someone, an individual, has the right to choose what they do with their own body, subject to the exception where they would cause harm to others. So what I always say is where the choice and the question is one of autonomous choices of patients, there's no place for BOLM, which I hate, professional practice test, outmoded, rejected as a determinative test by Australia, Canada, other common law jurisdictions. It's a fettering test. It fetters information that is delivered to the patient. And if we truly want to embrace patients having autonomous choices, then professional practice test, as the lawyers define it, has no place. So, you've heard Chris and Montgomery, this was part of my life for very many years, and it was for us a very important case. We didn't know we were going to win, as we did ultimately after failure in the Outer House, failure in the appeal court in Scotland, and everyone thought we were quite mad with our ideas, to be honest. But what's Montgomery about? It's about choice. So it's about choice, options, alternatives. We say Nadine was not given information to exercise an informed choice. I don't like the word informed consent. I like information disclosure equals informed choices or facilitated choices. And her choices were elective caesarean section, big baby, small stature, lots of risks, or vaginal delivery with the option to opt out. And to enable her to exercise a choice in how she went forward, she needed to know the risks and benefits. So if you take that into your daily life, when you exercise choices, you don't just normally do what someone tells you to do. You ask questions and you think about the ups and downs. You're going to buy a house, you're going to do something major. So it's all about making informed choices, fully informed choices. So one of the threads that I'll talk to you about that's going to be raised, I think, in the Supreme Court is that patients can't be coercing doctors, and we accept that. And the GMC guidance does protect you in that if a patient is asking for something which really is quite going to harm them, and it went back to some of the I need my leg cut off cases, then you should have a discussion, but they also say you may want to refer to another practitioner and discuss reasons. That part of the guidance does not hand over to you as clinicians, I say, the right to start thinking about patients' best interests. I'll decide what the patient's best interests are here. So my remit was not to talk about Montgomery, which I do quite a lot, and I'm sure bore many people with, but it's to talk about McCullough, another failure in the Outer House in the Court of Session in Scotland, failure in the appeal court in Scotland, and now the Supreme Court has accepted the case to be heard in a few weeks, stunningly. The fact that they have accepted it would suggest to me that they want to do something, but we will never know what that is until we hear from them. So we are returning there, and here are the issues, and I think it'll be particularly interesting for you because it's another passion of mine that we couldn't deal with completely in Montgomery, and I guess I got lucky that McCullough came along, and I maybe got lucky that we failed, that we can take it down to the Supreme Court. So what is a reasonable treatment option? We want to think about that. And does that treatment option include only the options you as clinicians consider are reasonable? And do you need to talk about treatment options that you know your colleagues like or choose or prefer, or other colleagues think are the more reasonable one? Do you have to talk about fringe alternatives? Does that include the offer of no treatment? And this is a real hot topic. I know people don't like it, but the offer of no treatment is a valid choice, and people seem to not think about that. And then the court is also going to look at the Bowl and Bilitho test and whether it has any relevance. So there's really, in many ways, it's going to be doing some important things, I think. That's the bullet points on it. But something about McCullough. Mr. McCullough was a young man, became acutely unwell, went to hospital, Forth Valley. He had pericarditis with a pericardial effusion, cause unknown, possibly viral. He'd had a viral illness. An echo was performed, and that demonstrated that he did have an effusion. It was affecting the right side of his heart. And at one time, there was clinical evidence of cardiac tamponade. He was very aggressively treated, combination of specialties, got better very quickly. Repeat echo demonstrated reduction in the size of the effusion, not affecting the right side of the heart. And even, we put the echoes up on the screen in court, and even the lawyers could see the difference. I could see the difference. And he was discharged home, antibiotics, still we don't know the cause, idiopathic. And so he went home, very quickly started to feel unwell, and returned to hospital, and he said the same thing's happening again. He was very frightened. He'd been in ICU, he had been acutely unwell, they had consented to take him for pericardiocentesis to another hospital because they couldn't do it. So that was a big drama, and he's back again, pericardial pain, back to a general medical ward, echo performed, and again, it was very similar to the first one, not the second one. So you could see the right side of the heart being affected. And a cardiologist was asked to, consultant cardiologist was asked to review the echo. She said she went to see him, not to review him, but to put the echo in clinical context. And because he was not in pain at the time that she saw him, she didn't prescribe non-steroidal anti-inflammatory drugs. Had he been in pain, she would have done so. As pain relief, she normally did prescribe such drugs. She made a decision, one, she wasn't going to prescribe them, and two, she wasn't going to discuss the prescription of them. So the experts, the defender's experts, supported the decision not to discuss or prescribe non-steroidals at the time of the review. This is the problem with Bolam. If you can produce somebody who's prepared to defend the practice, said, well, some people will do it, but I mean, I wouldn't have done it, but some people will do it, then it's not negligent. We actually did get a finding of negligence at the first instance against the doctor on this, but on not doing a repeat echo, but not on this. So he said, yes, I would have done it, but they all wouldn't. And the procedures expert, our expert, consultant cardiologist, said, yes, it should have been prescribed. The European Guidance for Cardiologists recommended it, and all major textbooks recommend it, not restricted to pain. And the defenders were saying, well, we've got the breach of duty case, but we've got the information disclosure case, and because the doctor didn't think it was reasonable, there is no duty in terms of the Montgomery test to discuss the option with him. She had, however, talked to him about pericardiocentesis, which was very strange, because she wasn't recommending that either. So he remained in hospital. He was deteriorating, but no one saw him. The physicians thought the cardiologist had excluded a cardiac cause. He was discharged, no further echo to check the size of the effusion. His wife, there's records of her fighting for him not to be discharged because he was so unwell. They did call the cardiologist. She was at another hospital doing a procedure. Didn't advise him he didn't have to stay. And he returned home and he died the next day. Cardiac tamponade as a result of the pericardial effusion in front of his wife and young children, baby. They tried to resuscitate him without any real result. So there was a breach of duty case based on the failure to prescribe the non-steroidals under the traditional, the Scottish test is Hunter against Hanley, the English is Bolam. They're virtually the same. Hunter against Hanley came first, Bolam followed and adopted some of what was said in Hunter against Hanley. And it was argued, as you've heard from Chris, about Belitho, which I use quite a lot. There's nothing logical or reasonable about failure to prescribe non-steroidals against the backdrop of that case. The judge didn't accept that. So we said, well, our view, supported by the college, European guidance, all the textbooks, is entirely reasonable and logical to prescribe. And we said Bolam does not apply to information disclosure choice situations following Montgomery. And non-steroidals was a reasonable treatment option that should have been discussed. And very strangely, the judge in the case, although we didn't succeed, actually said that both views of the experts were reasonable, which was quite a strange thing, because usually the judge goes down one way or another. So what then happens is you have to show causation or hypothetical or counterfactual situation. We don't know what would have happened had he had non-steroidals. So in court, we would need to show, well, if there had been a discussion, what would he have done? This is usually the Beecher's book of problems for pursuers or claimants in England, because the judges say, oh, well, you know, they say now, if they're alive, they say now they would have done something different, but they're doing that because everything went wrong. And the question of doing nothing was quite important here because, in my view, there should have been a discussion that if you don't take non-steroidals, there may be risks associated with that too. So we also would have to then show, one, that he would have taken them on balance, and secondly, what the difference would have made. And Mrs. McCullough said her husband was terrified and he would have tried non-steroidals. I mean, he'd taken Brufen at home, that was what was suggested. It wasn't big, heavy steroids. And the experts all agreed, even the defenders, that with a patient like Mr. McCullough, when given non-steroidals, they get better and they get better quickly, and they rarely proceed to tamponade and death as they are treated. Very strange. The judge said he had not enough information to make a finding on causation, and that we'll have to deal with that in the Supreme Court. So, from your perspective, the Scottish court's saying Montgomery imposes an obligation on the doctor to discuss the risks associated with a recommended course of treatment and to disclose and discuss reasonable alternatives, but it does not go so far as to impose upon the doctor an obligation to disclose and discuss alternatives that he or she does not, in the exercise of professional judgment, regard as reasonable. Now, then saying they'll be liable for consequences. So what does that do? That's the court doing exactly, it's like almost wiping out Montgomery and taking us back to Sidaway days and putting it all back to the doctor to choose, in my mind. And the GMC guidance is in direct conflict with that, because they're talking about you using the patient's views and their understanding of their condition, and you're identifying investigations and treatment likely to result in benefit for the patient. And then it tells you to talk about options and setting out the risks, benefits, side effects, including the option to have no treatment. They do say you can recommend a particular option which you believe to be best for the patient. I'm not that comfortable. That's old words, but I see that that's there. But you shouldn't put pressure. And then it goes: the patient is the one who weighs up the benefits, risks, and burdens, and as well as non-clinical issues that are relevant. And this is the whole thrust of it. A decision is not simply about the clinically best or optimal treatment. There are non-clinical issues that are important to the patient. And that is, just because a patient doesn't agree with you does not mean that the patient is irrational or unreasonable. So in Montgomery, the GMC were permitted to intervene in the Supreme Court, which I think was right. That allows them to have a voice. They had a written presentation and also a short oral presentation. And I agree that it's highly important that it wasn't lawyers devising rules for doctors. And they gave a very good presentation. They have been permitted to intervene in McCullough, which is coming up. But the BMA have come in this time, because the BMA apparently represent the views of all doctors in the world, well, in the UK. And so they feel that it's really important that their voice is heard to say what the medical profession want and need. And it may be that they are seeking to say that this duty should be ring-fenced, and that you do not have to go wider and talk about other options, such as you might say, well, I can offer this kind of treatment, and this involves this and this. What I can't offer you is X. That's another centre, another place, but you could go there, and I can't counsel you on it because I don't do it, but they don't want that. They want you, just a situation where, as I understand it, they will be saying that you only need to talk about what you know. So, as I've said, these are the issues. And they are really important issues, I think, because Montgomery, we didn't need to argue about the reasonableness of the caesarean section and proceeding to vaginal delivery. That was not a big part of the argument, although it did come out. So this is good because it means that the court can shine a spotlight on the issue and clarify it for you so that you know what they think about this. There was a case, Birch, which was pre-Montgomery, and this was where the court actually did say that there should have been a discussion and that duty is not discharged unless the patient is aware that fewer or no risks are associated with another procedure. And as I said, the other Commonwealth jurisdictions, we spent a great deal of time researching and working on Canadian and Australian cases, as well as South African cases for Montgomery, and have done for McCullough. And they have for a long time recognised is for the courts to assess and delineate the duty of disclosure in a case. And if the patient is not given sufficient information upon which he or she could reach an informed decision whether to accept a treatment, then there is no valid consent. And I use valid consent, not informed consent, because you can't have informed and uninformed consent. You can only have valid consent. So the key is sufficient information to place the treatment options in a proper perspective. And as a generality in the case law from Canada and Australia, it is recognised that disclosure is based on the patient's right to self-determine what should be done with their body, and such a right should not be at the disposal of the medical community, i.e. Bolum. So Rebel against Hughes, for those who, I know many of medics do a lot of law courses as well. Rebel against Hughes is a great case, very interesting. It is not shutting, they do not shut out the medical profession. They say the medical evidence is relevant, but is no longer decisive in determining whether or not sufficient information was given to a patient to enable the patient to make an informed decision. The test used focuses on what the patient would want to know, and that must include options for treatment if approached in this way. Another Canadian one, fantastic case on options, Van Moll. Again, they talk about risks, discussion of risks, discussions of options, and it's really important as well as the thread of the Canadian cases is that that also includes what happens if you do not have a procedure. Senny against Cooks, another really good Canadian one which I highlight because it says in terms, however, the fact that a doctor simply preferred one treatment over another did not relieve them of the obligation to advise of other acceptable and known procedures. And there was no suggestion the doctor didn't know. But clearly, as a practicing clinician, you are duty-bound to keep on top of what's going on and the other alternatives that are out there. And the court was clear that reasonable alternatives may also include procedures which other physicians may recommend, but the treating doctor may not. And I think you can take from that that is part of the thrust of the argument that has gone in on behalf of the claimant family in McCullough. So the hearing's set down for the 10th and 11th of May this year. It will be 1.5 days. It's tightly timetabled. The decision will not be made immediately. The court will take time to consider it. Montgomery took quite some time. And I remember in the midst of it, I met Lady Hale, who had heard it, and I had said to her, I'm waiting for the decision. It's the first thing I think of when I wake up in the morning, the last thing I think of when I go to bed at night. She didn't say, oh dear, you need to get a life. She did say, you'll be waiting some time, this is going to take some time. I think McCullough may not take as long because Lord Reid and Lord Hodge, who are two of the Scottish judges who will hear it were also in Montgomery. And it seems clear to me that something will happen. I can say that we're more polarised than we were in Montgomery. The argument that is very fixed against us is that reasonable treatment options belongs to you as the medical profession, solely to you. So watch this space. Thank you.
That was great. Thank you very much, Lauren. Any questions, please? I'm sure there would be plenty. We have 10 minutes to finish off the questions.
Hi, thank you so much for those talks. John Leach from Manchester. Just a question to Lauren Sutherland, please. Thank you for that talk. As a spinal consultant who's trying to involve patients in consent decisions on a daily basis, like all of my colleagues here, I was somewhat terrified hearing about that McCullough case, because I'd just like to ask, what role is there for clinical judgment for a specialist in terms of distilling the information you give to a patient?
Yeah, that's a really good point. I mean, I would like you to understand that the purpose of the case going is not to beat some drum to try and make your lives more difficult than it already is, because we recognise that there are problems. The purpose is to clarify the law is developed, as you may understand, in the UK by these cases, and it is an area where there has been lawyers fighting about what it really means. To me, it seems very clear, but they have legitimately raised these issues, and I think it's a legitimate issue for the court to be thinking about treatment options and what you should discuss. And I think that they will say that you do not have to discuss every single possible treatment option. And I think they will also say that your clinical expertise must always be relevant. And you know that the GMC now like the word shared decision-making. It's not my favourite. I prefer facilitated decision-making, because the decision is actually the patient's decision, facilitated by your clinical learning and expertise. And it will still allow the patient to say, as many do, I'm sure, I don't know, I don't want to hear about it, you tell me what you think is the best thing to do. That's will still be perfectly legitimate, and that is a legitimate response. But I think what they will do is allow, it can only be permissible to allow you to bring your clinical expertise as best you can. But I think where my big problem with this has been a number of series of cases where I've seen one in particular which was very distressing, of a young child, and it's a Scottish healthcare problem, where they were not told, the parents were not told it was a benign tumour, and it was an adult neurosurgeon operating on, and it's in court, so I'm allowed to talk about it, an adult neurosurgeon operating on a young child, not a paediatric neurosurgeon. And there was no MDT and there was no oncologist, and parents were not told that in the centres in Glasgow and Edinburgh there were MDTs, there were oncologists, there were paediatric surgeons. There was a wholly different regime, and the child was devastatingly injured during the surgery, to the extent that he now has to live in supportive care he's blind and unable to function. Now, these cases concern me because all that needed to be done, and the unit was there, and we've spoken to the Glasgow and Edinburgh doctors, was a phone call, or to say there are centres in Glasgow and Edinburgh who have a bigger facility, they have more specialism in this kind of surgery. I do think that there has to be room for that, because we can't have small centres who don't do any of the research or the work, just hanging on to people and not telling them things. And I thought it was excellent when I heard the speaker who said that they had a special consent process because they were doing this procedure. And actually, if you take patients with you and talk to your patients, the outcome, even if there's an adverse outcome, the patients tend to have a different approach. It's when the patients feel that they've been railroaded, is a word we hear, railroaded into something, not given information, they find out afterwards. That's the trigger to go to lawyers. And believe it or not, it's a bit like turkeys voting for Christmas, but our thrust is not to have patients coming to lawyers. Our thrust is for better patient safety. And I think Chris could pick up on one of the themes that we think is good is the idea of video recording of consent, not so that we can catch you out if you go to court and put more pressure on you, but to allow patients to take it home, or to use nurse practitioners, or to use documentation, online videos, ability to talk to other patients. These are things that will enhance the patient experience, but also their understanding, and may take some of the pressure off you. I think Chris might want to say something about recording.
Only that it's, if we're talking about having a complex dialogue, then it seems to me it's incapable of being captured in a note. And afterwards, whether the person litigates or not, it may be useful to work out what was said, in fact. I'm probably against myself the idea of the patients video recording these things.
Yeah, I think there is a problem with, if you see the new GMC guidance, there is a section about recording, and I've already raised this with doctors that they don't seem to have put in this sufficient security for doctors in this situation, because if a patient videos, it seems to be what they're saying is that that's the patient's property. They take home and show mum or dad or a family member or a friend, this is my consent process. But what does worry me about that is that then can be used in any way that you have no control over. So if people are thinking about it, I think trusts will need to be cognizant of the fact that you'll need to have some element of protection about the use. If the doctor videos it, it becomes part of the patient's notes. But again, patients have access to their notes. I wouldn't like to think of it as a sort of defensive medicine approach. I would like to think if we were videoing, it would be to facilitate and help a patient who's trying to understand maybe something complex. And the other aspect is, and lawyers are guilty of this as well, is we need to learn how to talk to our patients in language that the patients can understand, and taking your huge skill and then making it palatable, edible for someone who's perhaps not, has no medical education. And also facilitating questions, because one of the workshops we did, the consent processes were fabulous, and everyone that watched said, yes, they've done really well, they've told them about this, they've told them about options. And then the point I made was, and when did the patient speak once? And so you need to think about that, because if you're talking about engaging, you have to facilitate the patient to ask questions. Maybe not at the end, but when I do it with them, it's in short bits, and then did you understand that? And because I've got to tell them about the medicine, as Chris does with our cases. So we have to make it palatable, and then we put it into small sections and check what they understand. So these are all other things, but your clinical judgment is not part of our argument that clinical judgment does not mean anything. And I don't think, never 100% sure, you don't predict the Supreme Court, I do not think they're going to take clinical judgment out of it. I think what would be interesting would be to look at the views of the profession, but not as determinative, and that the court should look at the spread of the views of the profession. So, for example, if there was an ex-spinal procedure, then you say, well, what was this doctor's view of the procedure and the risks and benefits? And then you go wider, then you sweep. It's almost like Belitho. But is there anything else in the literature? Is there anything else in textbooks? Is there anything else in research? And is there anything else that others think? And I think my issue would be, for example, in McCullough, which potentially two schools of thoughts on the non-steroidals, but the court found them both legitimate. And if, in my view, if both were found to be legitimate, both needed to be discussed. And then the court would make the analysis based on what you did. And I do appreciate it's not easy at all for you.
We're nearly time, but we'll have one or two quick questions.
Thank you very much. The question is, when I was listening to Chris's talk, it appears that consent has to be an individualized process for each patient separately. So are the days of pre-printed consent forms with all the lists of the risks gone, or are we still allowed to use them?
Thank you for listening. In my judgment, they should probably become a thing of the past insofar as they require or depend on the signature of a patient. But if you want a bullet list of things that are relevant, then I think that's always helpful. And so a tick list of what that would include: what is the presenting complaint? What is the purpose of the surgery? What are the alternatives? Is there an alternative of doing nothing? Any particular features for the patient? It seems to me that that would be a useful but not exhaustive list of bullets that you could use as an aid memoir. And if that then informed what you told them and that was recorded or written down, that would be helpful. And then I'm just going to mention one other thing actually about the idea of recording. It seems to me that consent to such a massive thing shouldn't be, as it were, a transactional process that results in consent or otherwise with a signature, but rather it should be an ongoing one for the patient, which may cause problems for lists, but so that when they took it home, they could see the exchange that took place, or they could log in to the website with a password that showed what had happened, and say, actually, you know, I was overwhelmed, or I couldn't take it all in, even though I seemed to be asking the right questions. It is, as they say, complicated, and I sympathise with your situation. Alex is sitting patiently. It's now 6:30 in the morning
Yes.
in Chicago, where he is.
I think we'll take one last question from yourself.
Hi,
You've
Mark,
been standing there patiently.
Walton Centre in Liverpool. You've, in a very eloquent way, described 70 years of legal argument and development. Should we now use this more complex process in this consent validation and demand from our medical administrators the appropriate time frame to allow to do this, rather than being told by our medical management team that you have 15 minutes to see a follow-up?
So I think the question also provides the answer. It's self-evident, isn't it, that because what strikes me, and what strikes Lauren, I know as well, is this, that without trying to butter you all up, what you do requires far more skill than ever we could muster. And yet, perhaps the most important decision is not the technical one as to how to do it, but rather the more easy for me to say, philosophical one as to whether to do it. But definitely, yeah, you need more time, and you need to persuade the managers to give you more time.
Thank you.
That's a really good point, and that is something that we had raised, that time is important, but the other aspect is that you do get better when you start to do it more. There was one point I think that is quite relevant to you all, and it's an issue of MDTs, and so the decision of the MDT has been taken to the patient, and I appreciate that you cannot have the patient at an MDT when you're discussing a number of different patients, and that's entirely reasonable. But we have hit upon a situation where the MDT is God, and the MDT has decided, because we've got more than one doctor, it must be right. And we can't sue an MDT. We try and just find the individual member of the MDT who's made the mistake. But people do bring mistakes into MDTs. And I had one very good doctor who did say, well, what I do is, because I said, how do you take the views of your Montgomery says you have to take into account the views of the patient. how do you take that to your MDT? And one doctor said, I take it to my MDT, and how I do it is I speak to the patient before the MDT. So I know what my patient's views are. And the Montgomery test is a twofold test. And the second aspect is that, you know, you could be hung on things that, say the patient said to you, I'm a professional dancer and I need X, Y, Z. That needs to go to the MDT, a professional footballer. Or, and some people have also suggested asking patients to fill out forms before they come to, I know we've got forms and forms and more forms, or a computerised thing to say what's important to you, what's the most important things that you hope to gain from this surgery. And I heard a really important one from, it was a vascular surgeon, and a lady was going to get surgery. And then when she filled in one of these forms, she said, it was a knee surgery with some vascular consequences. And she said, the most important thing to me is my garden. I can cope with the pain, but if I can't go do my garden, I couldn't live. I'm retired and that's all I have. And the inevitable cause of the surgery they were about to plough ahead in would be that she couldn't kneel in the garden. And they said that to her, and she said, well, I'll do without the surgery, I can deal with the pain. So that's why patients' views are important, so you might want to think. And when you deliver your MDT to the patients, remember that is not the end of it. You can say, the MDT have considered it, and this, but there are still these other options, and the patient can pick the option that is not necessarily what you think is the clinically optimal option. I think that's a good way to stop and get your lunch now.
Sorry, I think Alex may have a comment. And I always tell my colleagues that MDT does not have a GMC number.
That's true. That's absolutely right.
Alex, please. Thank you for joining us.
Thank you very much. Can you hear me okay?
Yes.
Conscious of time, and thanks to Chris and Lauren for excellent discussions, really absolutely key game-changing points to be made. I just had two comments really. One was emphasising the importance of the GMC's guidance on the principles of decision making. I think it's fantastic, and one of the areas, and I know the constraints of times, but one of the important areas is overcapacity, mental capacity, really key part to decision making, and as Lauren has mentioned, facilitated decision making. The second point is that with McCullough, to me, it demonstrates the challenges that go with having multitude sources of recommendations and guidance when reference to the European guidance for management of pericardial effusions and textbooks. And I think this emphasises to me the importance that if there's a claim, there are a number of recommendations and recommended guidance. And what we're interested in at NHS Resolution is trying to bring together those such that they're in a more palatable form. And so, again, I would emphasise the offer is out there to meet with any relevant clinicians to talk that through, because I think it's really important that it's important to make it easier for the patient to make the right decision, and it's important to make it easier for the clinician to make the right decision with this particular work stream. Thanks.
Great. Thank you very much, Alex. Thank you, Lauren and Christopher.